Top of the top, y'all. It's your boy Real Estate Show tapping in. And today we're going to talk all about Affidavit of Heirships, or AOHs as we like to call them. I'm going to run y'all through exactly what an Affidavit of Heirship is, why doing an Affidavit of Heirship is so important, the benefits of an Affidavit of Heirship, things like the cost, how long it could take, and everything surrounding that process. Next, I'm going to walk y'all through step by step on how to complete an Affidavit of Heirship forms, one of the same ones we submit to our title company on a weekly basis. Lastly, I'm going to walk you through the next steps of an Affidavit of Heirship process after you complete the form. That way you know exactly what to expect when you are going through this process yourself. Now, please keep in mind that I am in Dallas, Texas, all right? So if you are not in Texas, there may be different rules that apply. There may be different requirements. So, take this video with a grain of salt. Always consult with your title company because they have underwriters and title attorneys who can walk you through this process. Well, they won't walk you through this process, but they'll let you know what the requirements are and confirm any information that you may see here. And even if you are in Texas, still consult with your title company because it's really important to know that every title company is going to have their own version of the Affidavit of Heirship form, okay? We're going to use one today that we use in one of the title companies that we work with, but they literally all have different forms. Very similar information. Sometimes it's almost the exact same document, but somebody might require the last four numbers of a social security, and the other title company might actually require the full social security number of the person who is deceased. So it's very key that you get an exact copy of the Affidavit of Heirship form directly from the title company that you are working with for your specific transaction, okay? Affidavit of Heirship, or AOH, is pretty much a paperwork determining who the heirs of a property are, or who get interest or ownership in a property after someone else passes away. And an Affidavit of Heirship is necessary for anybody who passes away that did not leave a will, last statement, or designation as to who the heirs of the property will be. And even if they did leave a will, if it was never taken to court and probated within the first 4 years of them dying, then the will would no longer be valid and you would have to do an affidavit anyway, or you could still go to probate court. The will just would not, apply. Now, AOH is important for obvious reasons. It helps determine who the heirs of a property are. So if someone dies and leaves behind a property, the family doesn't want it to just sit there. You either want to be able to take care of the property and agree as a family to do that, or agree as a family to sell the property and take the cash proceeds, and do with it what you will. The benefits of doing the Affidavit of Heirship means not having to hire an attorney and pay a $6,000 plus retainer to start the process. And that could get even more expensive as the process goes along, depending on who's missing from the picture, what information is missing from the picture, how well the family communicates and gets along together. I mean, those are all factors that could play a part in how long a probate process can take and how much it could cost. An affidavit is also much more time efficient than having to go through the probate court, all right? Because you have to hire an attorney, like I said. You have to file a petition to go to court. You have to get a court date. You have to round up all this information. Everybody has to appear in court. And if you don't get it resolved on the first day, you have to come back to court. I mean, it could be a long, drawn-out process, whereas for us, we've been able to complete Affidavit of Heirships anywhere from 2 to 8 weeks, again, depending on how well the family communicates with us and provides the title company the information that is necessary to complete the Affidavit of Heirship process. Doing an affidavit is also cost efficient. Now, I have already mentioned having to hire an attorney and pay a $5,000 to $6,000 retainer, but when we do the Affidavit of Heirship, depending on how many heirships are needed, and an Affidavit of Heirship is needed for anyone in that heirship line who has passed away, okay? So if a mother passed away and she also had 3 kids and one of the kids passed away, now and able to complete this process, we have to do an Affidavit of Heirship for the mother and for her child who deceased, okay? So when you do an Affidavit of Heirship through a title company, each affidavit could cost anywhere from $300 to $550 from what we've seen in our experience, all right? So you would have to do 10 affidavits to equal the cost of hiring an attorney and going through probate court, okay? So that is what I mean when I say cost efficient. And most of the deals we do only require 1, 2, or 3 affidavits. So we're talking about $1,500 compared to $6,000 to $10,000. It makes sense to do an affidavit of heirship if the person has passed away, they did not leave a will behind, and the family is all in agreement to sell the property. They just need help with the process. But now it's time for the step-by-step, y'all. Let's do it. This questionnaire is designed to aid in collecting the information typically needed to complete an heirship affidavit. Please answer all questions clearly and completely, okay? So that's really important, guys. Don't leave anything blank. If it doesn't apply, write NA, but don't just leave it blank because they assume that maybe you just didn't have the answer, and that will be a red flag when you go to turn in your completed affidavit of heirship, all right? And if there are any holes in the affidavit of heirship, like I said, that can be a red flag, and the more red flags you generate, the less likely the title company is to accept your affidavit of heirship, because a lot of people lie on these forms and put misleading information so they can purposely leave out other heirs who may have interest in the property, okay? So know that is very common, and you won't get away with playing around, all right? So put all the honest and true information in here, because there are a lot of ways for a title company to discover the truth. All right, so provide full names when responding. Information provided in this questionnaire may be used by an attorney to prepare a legal document. It will be used by an attorney to prepare a legal document, okay? After you complete this form, this is like a rough draft, and then the title attorneys will go through and review everything, bring up any red flags, make sure everything is on the up and up, all of the information matches, and then they will kind of type this up and redo the affidavit, and that will be the final copy that will need to be notarized and will be submitted to the county for recording, all right? So use the back of this form if any additional space is necessary to complete an answer. Please refer to the question number, all right? All right, so let's get down to it. The person giving the affidavit, that will be you. If you are the person filling out the affidavit, then your name goes up here, okay? So for the purpose of this video, I'm going to be the person giving the affidavit, so I'm going to put my name. All right, Andrew Howard. Then I'm going to put my address. Remember, guys, we want to put a full address. Don't just put the street name, put, the zip code and everything. This is not my real address or zip code, so don't play. Relationship to the decedent. So if you're the person giving the affidavit, what is your relationship to the person that died? Because remember, we only need to do an affidavit of heirship if someone who has interest in the property or the owner of the property themselves has passed away. An affidavit is only done for people who are deceased, all right? So I'm going to put brother. So let's just say my brother passed away, and my brother personally is good, well, and healthy. Okay. I love my brother to death. I do not want to jinx him. I'm only doing this for the purpose of this video. So you guys can get a real life example. Okay. But my brother is perfectly well and fine. So you will put your relationship to the person who is deceased. Number 2, provide names of 2 disinterested witnesses that will sign the final affidavit, verifying that the affiant's statements in the affidavit are true. Witnesses need not sign this questionnaire. So you will need 2 witnesses to complete your affidavit of heirship. And what they are witnesses to is the information that you are putting in this document. They are saying, yes, I knew the decedent. I knew his family. This person is his brother. He had 2 more brothers that are listed here in this document. So they are just pretty much confirming the information that you are putting here. And any witnesses, you see it says disinterested. That means the witnesses cannot have an interest in the property, meaning they cannot be getting money for the sale, or otherwise they will be willing to lie on this document, okay? So this could be people who are not directly related. This could be friends of the family, church members, co-workers, family friends, anybody who is not directly related to getting interest in this property, okay? So I could use my cousins in this instance, but I could not use my sister or my mom because they may be getting, a portion of the sale. All right, so you want to put the witness's name, John Doe. You want to put their full address, and I'm just going to copy and paste this address, okay? The relationship to the descendant, I'll put family friend. Again, guys, make sure you're filling in every line, okay? Number of years, witness knew decedent. The witness has to has known the deceased person for at least 10 years, a minimum of 10 years before they died, okay? If that is not the fact, then you will have to get another witness. Keep that in mind. That is very important information. The witness has to have known the person who died at least 10 years before they died. So, and since this is a family friend, I'm just going to say the second witness is Jane, though. So this might be John's wife, okay? So she is also a family friend. But she knew me and my brother for, 10 plus years. So full legal name of decedent. This is the person who died. So I'm not going to put my real brother's name. I'm going to call him John as well, okay? So John Howard, my brother, had no other aliases or AKAs, all right? So I'm going to put the social security number of my brother, the person who died, all right? His age at death, we'll just say he was 30. And then the date of his death, we'll put today's date, 2/18/2024. Country and county and state where decedent resided at time of death, Dallas, Texas. County and state where decedent died, Dallas, Texas. And these are two different questions, okay? So where did he live at the time of his death, meaning what county and state did he live in, and then number 7 is what county and state did he actually die in, okay? So these are two different questions, guys. Then you also must attach a copy of the death certificate, okay? This is very important. You cannot submit an affidavit of heirship form without the death certificate for the person who passed away, okay? You have to attach it. If that person recently passed away, it usually takes about 6 weeks for the funeral home to produce that death certificate, all right? Just FYI. Number 9, did the decedent have a will? If they had a will, you will go to question number 10. If they did have a will, keep going. If they didn't, skip to number 10. So for this instance, we're going to say no. Is a copy of the will available? We're going to say no because there is no will. But if there was a will, then you want to put yes and put yes if a copy is available. If it isn't available, explain why not. This doesn't apply because I said we didn't have a will, okay? Has there been any probate or administration filed with respect to the decedent's estate? So if there was a will, and sometimes even if there's not, families go to probate court, and that is the important piece of doing an affidavit of heirship, because if there is no will in place, then that means the person who passed away did not already have an idea of what they wanted to do with their property and how they wanted to divide that interest. So that is the purpose of this affidavit of heirship. Now, if there was a will left behind, I suggest to families that you actually do attain a lawyer and go to probate court. So, what the decedent actually wanted to happen can actually be brought to life through the court system, okay? We don't want to disregard someone if they actually left a will and a final statement behind on what they desire to be done with their property. You want to see that through, and in order to do that, you need to go to court, go through the probate process, unless the family agrees to do that, a mutual agreement, and then they can do the affidavit of heirship process. But I am not an attorney. I am not a legal advisor, none of that. So, do whatever is right for y'all. But if you're doing the affidavit of heirship, this is how it's done. Has there been any probate or administration file? We're going to say no to this. All right. And then this does not apply. And if it was, there would be a case number, but this does not apply. Okay. So marriages, complete the following, listing all spouses, addresses, and dates and places of the respective marriages. If they were never married, we're just going to click this box right here. Okay. Let's say that he was married. If the person who deceased has been married, you must list all of the marriages. It don't matter how bad the marriage ended, how much you hate your stepmom. It does not matter. Okay. Every marriage must be listed. That is very important. You have to list the spouse's name, the date and place of the first marriage. So that could be Dallas, Texas, Fort Worth, Texas, whatever. Generally, city and state will suffice here. And then date and reason for termination of the first marriage. Did somebody die or did they get a divorce? And then you need to know the place of termination of the first marriage. So if one of the weds, if they died in Dallas or if they got a divorce in Dallas, you will put Dallas, Texas here, okay? But you have to answer all this information correctly. Second marriage, you're going to fill out the same exact information. Third marriage, if there was one, fill out the same exact information. If there is a fourth marriage, you put that information on the back of the sheet, like it said at the top of the form, okay? Don't leave stuff out just because there wasn't enough room. You want to put all information that applies in this affidavit. Very important. Children. List all children of the decedent, whether living or deceased, okay? Including adopted children or children taken into the decedent's home. So children of the first marriage. So if my brother had children with the first wife, I will put all of their information here. Remember, all forms, all lines have to be completed. If that does not apply, simply put NA, okay? Now, I'm not going to put NA on all of these just to keep this going. But if it does not apply, just put NA, or you can just strike a line all the way through this if it does not apply. Okay, but don't just leave it blank with no indication of if the information doesn't apply. So then children of the first marriage, want to put the name of the first child, first and last name, the date and place of birth, were they born to the marriage, or were they a stepchild? If they were not born while the couple was married, you would put no. Was the child adopted? If not, put no. What's the current address of the child? Okay, not of the parent, but of the child of the marriage. What is their current address? Are they living? Are they deceased? If they are deceased, when and where? Are they married? If they are married, provide the name of the spouse, okay? And I know this is very detailed information, but it's very necessary when you're talking about real property in Texas, okay? So same thing with the second child, third child, so and so on. Then they ask the same questions for the second marriage, if that applies. Same question for the third marriage, if there are children from the third marriage, and so on and so on. Then, were there any children born to the decedent outside of marriage? So kids that he had with women that he did not marry, okay? So same information, name of first child, date and place of birth. Were they born of a marriage? No, obviously not, because that's what this question is. Were they adopted? Their current address? Are they living, deceased? Same exact questions, guys, all right? Now, does the deceased person have any deceased children? Because this is going to be very important as well. If they have deceased children, you want to put that information here, because even if he had deceased children, then their children will have interest in the property, okay? So the lineage gets pretty long. That's why it's so important to include all family members involved in the process. So children of the marriage, deceased children, deceased child's children, because these children would then get the inheritance portion that this person was going to receive. So same information, okay, for the deceased children. Now, question 14, if no surviving spouse or children or any other decedents exist, list the decedent's parents, their dates of death, and if applicable, the county and state where the parents died, current address for parents if living, and the names of the children born to or adopted by either parent. If either mother or father is deceased, please provide the same information on all of the decedent's siblings, okay? So if the person died with no kids and no spouse, then the next people in line to receive his inheritance would be his parents. But if his parents are also deceased, then his brothers and sisters will receive his inheritance, okay? So number 15, what was estimated value of the decedent's estate as of the date of death? I have no clue how much my brother was worth, so I'm going to put ENA here as well. A lot of the times the families really don't have a clue what all their family members possess until they die and things start coming out. So a lot of times we put ENA here, but if the family knows that the person who passed away is worth $500,000, put $500,000 here. 16, are there any outstanding unpaid debts of the decedent's estate, such as funeral, assisted living, or nursing care bills, doctor or hospital bills, or any other debts? If yes, list all debts. Don't include loans secured by recorded liens against the property that are being paid at closing. Attach additional pages if necessary. So if the decedent was in the hospital before they died and racked up a hospital bill that insurance didn't pay for, title company is going to want to know that here. If we buried the decedent, if we buried my brother without paying for his funeral arrangements and there's a balance owed on that the title company is going to want that listed here, because all debts must be satisfied before any of the monies can go out to the dead person's heirs. Okay. But you'll see they say don't include loans secured by recorded liens against the property, because if there are recorded liens against the property, like a mortgage, back taxes, things like that, then those are already going to be found on the title record, and they're going to have to be paid off at the closing anyway. So you don't want to put anything like that here, but any other debts you will list on this form right here. And the amounts if you know them, obviously. 17, was the decedent receiving Medicaid benefits for healthcare services prior to his or her death? And you do whatever applies to your dead person. Yes, no, or you don't know, okay? Because if they were receiving Medicaid, again, the title company has to verify that all debts have been paid to those care providers before they can release money to the heirs of the property. Then you simply date. And then you're going to sign and print your name as the person filling out the affidavit, okay? And that's it. So there y'all have it. That is how you complete an affidavit of heirship form. It is really general and basic information. Again, the most important thing is filling out all of the information completely and making sure that it is true, making sure you have a witness who did know and knows some history of the family and has known the deceased person for at least 10 years. That is very key information. Make sure you have the right names, the right birth dates, the right social security numbers, all of those things. And make sure the addresses are right as well, because all of this information will be going into a legal document that is prepared by the title attorneys. And once this is notarized, meaning, somebody witnessed this and said that you signing this and your witness is signing this, promise that this information is true. And then this is recorded with the county and makes a big decision on who the heirs are to a property, okay? And who gets interest, who gets inheritance, and who gets money from the sale of a property. You want to make sure all of this information is true and correct, guys, because it can come back on you. You can get sued for this. You can go to jail for putting wrong or misleading information on the affidavit of heirship. So after you got your affidavit of heirship form filled out, you're going to submit this form right here to the title company along with the death certificate of the person deceased. And if they had a will, you want to submit that document as well. Title company will receive this, review the information with the underwriters. If there are any red flags like missing information, or if they pulled up records online and it says that their dates show a difference in the dates that you put, then you're going to have to go back and correct some things, verify some information. But once you get everything good as far as information and the underwriters give you the green light, they say everything looks good, then they will start to prepare the final affidavit. And this is where they take all of this information, type it up into a formal affidavit, and then they will have the document signed and notarized by you and your witnesses. And once the notary signs, stamps, and verifies that information, it will then be sent back to the title company. They have to have the hard copy. That'll be sent back to the title company. They will re-review it, make sure the notary and all of the parties signed in the correct places. Then they will record that document with the county. From there, they will update the title, and the title will be updated from the deceased person's name to all of his heirs' names, okay? That would then give us the power as the new owners to just keep the house or go ahead and sell the property, as a lot of people do, and that's what we're talking about on this video. That will give us as the heirs the legal right to go ahead and sell the property. And typically after everything is notarized and recorded, the process is over. So it's really a simple process and can be fairly quick. I mean, we've been able to get affidavit of heirships done in 2 weeks, 3 weeks. It really depends on how quickly you are communicating with the title company and getting them all of the information that they need, filling out the documents correctly, make sure everybody is available when it's time to get them notarized. And the process can go fairly quickly. Now, we have seen the probate process take anywhere from 12 to 36 months. Yes, up to 3 years. I mean, we've dealt with a lot of clients who are saying who tell us, hey, we've already started the probate process. So when the probate process is already started, there is nothing that we can do. We cannot stop that and then just start an affidavit of heirship. We have to respect that and let the family complete that process, okay? So in our experience, we have never seen one take less than 12 months, but I can only talk to y'all from experience. What I do know is when you fit that bucket, the process of going through probate is a lot more time consuming than doing an affidavit of heirship, and that's facts. If you got any value at all from this video, go ahead and hit that like button, subscribe to my channel if you haven't already, and go ahead and hit that bell so you can get notifications every time I drop game just like this. The affidavit of heirship process is really important to my business. Hopefully I was able to add value to some other real estate entrepreneur out there. That's the reason I drop these videos, just in case, you know, you happen to stumble upon this, you really are able to take away some game, and that helps you along in your journey and kind of lightens the load to, you know, kind of know exactly what to expect from these type of situations. But that's all I got for y'all today, man. Until the next time, tap in.